Hello and welcome back to the virtual classroom. I'm your host, Dr. Olmsted, and welcome back to part B of our lecture regarding civil rights in the age of conformity. And so we talked about rock and roll, music, literature. We talked about Longoria Fair and the formation of the GI Forum. But one of the biggest places we start to see some civil rights breakthroughs is through some very important court cases. Now, again, none of these in and of themselves are the end, but each one builds upon the other one, and they form the building blocks that will eventually lead to the takedown of segregation. And so it becomes this issue over school segregation. They had long been a priority for Mexican Americans, as Mexican American children had always had a difficult time, either A, being forced to never speak Spanish in a white school, or more often segregated into a Mexican school that was poorly funded, lack of resources, and still facing the prejudice and bigotry and being told you can't speak Spanish. Remember, Latino children were most often forced into separate schools based on the racist idea that they were too black or too stupid to simply understand, to grow and develop and learn, or that they were just better off serving as manual laborers in their future, so why bother educating them now? And of course, LULAC had been challenging segregation since its founding in 1929. So let me give you a quick brief recap of some of these major highlights of court cases. And of course, we talked about this before, I won't go into long detail again, but as a recap, Sava Tierra versus Del Rio ISD in 1930. This is the first case tried in Texas regarding segregation in schools. And it began as several Mexican American parents had filed a lawsuit against the Del Rio ISD, charging that those of Mexican descent, because of segregation, were being denied and deprived the benefit afforded to white children. Their students were being forced to attend the Mexican school. And of course, while they would go on to win locally, they would lose at the higher court level, which in the end did help to legalize segregation of children of Mexican descent through the third grade based on the separation of cultural and language difficulties. But this was still the Depression era, the repatriation era. So it started out as a minor victory, but ultimately becomes a loss in the short term. But in the long term, it does set a precedent. It does create a foundation to build on. And the bigger break in renewed interest in these civil rights cases happens during and after World War II. And so we're going to start with the big case of World War II, which is Mendes versus Westminster. This is a very powerful case. So the story goes, in 1945, a group of Mexican American families from the Westminster School District in California filed a lawsuit against 4 elementary schools in Orange County for actively segregating some 5,000 school-aged children solely because they were of Mexican descent. Now, at the bottom right, you see the main plaintiff in the case, Sylvia Mendes. And what happens is her father, who is a farmer, he's able to purchase his own land, and they move into Orange County. And when her aunt takes her, along with her cousins and her siblings, to register at the local school, the secretary basically barely looks up and says, "You guys can't go here," pointing to the Mendes children, but will allow the aunt's children to attend. And the basic premise is that the Mendes children were darker skinned. They looked Mexican, versus the aunt's children who were lighter and could pass for being Anglo. And the father basically starts a coalition, begins to gather people together, and they sue the school district. And so in 1947, a case was launched by Mexican Americans of Orange County, who would initiate a class action lawsuit against several schools districts in California. The goal to challenge these district segregationist policies. They argued that segregation was violating constitutional guarantees of due process and equal protection under the law of the 5th and 14th Amendments of the Constitution. Remember, the 14th Amendment, the Equal Protection Clause. This case, though, becomes a landmark case against school segregation. The state Supreme Court, led by future Supreme Court Justice Earl Warren, will rule in favor of the Mexican-American plaintiffs. And this became one of the primary precedent-setting cases for Brown v. Board of Education. And this is why, when I read the Secure These Rights a couple lectures ago, when the report mentioned education, it mentioned the discrimination in Texas, but it had also mentioned that in California, things had recently changed because that report came out in 1948, 49. This court case took place in 1947. So it just changed. And so the results of this, if you want a great, easy book to read, there's a great children's book on this called Separa's Never Equal. My daughter loves it. And so this becomes a monumental case at a state level that sets a precedent for the national Supreme Court decision coming with Brown v. Board of Education. But it wasn't the only one. And back to Texas in 1948, building on this, was Delgado versus Bastrop ISD. And so this case is launched against Mexican Americans in Bastrop County in Texas to end school segregation. They charged that the Bastrop ISD, just outside Austin, picture on the map, was violating the constitutional rights of Mexican American children, 14th Amendment, Equal Protection Clause. And the case went beyond just the Mendes decision. So it builds on Mendes and goes beyond it by defining segregation and that it defines what segregation is and prohibited even what was called de facto segregation based on race or ethnicity. In other words, even if it wasn't a law that said you must be separated from you, the very fact that it was happening was also discrimination. And federal courts ruled against separation of any kind of Mexican or any Latin American children in schools or classes, which means the court order also applied to Mexican immigrants as well. They did say, however, segregation based on language difficulties was allowed, but only in the first grade. And once again, this would end the practice of segregating Mexican American children officially in Texas public schools. Again, setting the stage for Brown v. Board of Education. Now, following these landmark cases for Mexican Americans, there would also initiate numerous additional lawsuits against segregated schools and districts that found ways to evade the anti-segregation rulings and that were guilty of, noncompliance. So again, they had their victories here. They won these court cases. But of course, we know people are still racist. People are still stupid. And they will try to find loopholes or just outright refuse. And so despite these landmark victories, school districts continue to avoid compliance. They will continue to segregate Mexican and Mexican American school-aged children until the next big push at the federal level in 1954. But while the fight against school segregation was ongoing, at the same time here in Texas, another segregation case was also being litigated. And that is the Supreme Court case, Hernandez versus Texas. Again, being largely supported by the GI Forum. And this is a court case where the Supreme Court recognizes that Latinos are suffering inequalities and profound discrimination. The plaintiff here was Pete Hernandez. Now, this is a little bit of a lengthy story, so bear with me for a minute and try to understand just what's all going on here. So in 1952, in Edna, Texas, Pete Hernandez, a 21-year-old cotton picker, had gotten into a fight with several men and was dragged from a tavern, robbed, and beaten. Upon reaching his home, he collected his .22 caliber rifle, walked 2 miles back to the tavern, and shot one of his assailants. With 40 eyewitnesses and a confession, the case appeared to be an easy open and shut case. He was on trial for murder. And, big surprise, he was convicted and sentenced by an all Anglo jury. This was not uncommon. This was normal, right? This was how things were done. But Hernandez versus Texas Supreme Court case turned into one of the nation's most groundbreaking Supreme Court cases in history. The problem with this case, according to 3 dedicated Mexican-American lawyers, was that no Latinos were allowed to serve on Texas juries as a result of rampant jury discrimination. As a result, this case, Hernandez versus Texas, becomes the first to recognize discrimination against Mexican Americans within the court systems. This is the first Supreme Court case ever briefed by Mexican American lawyers, by Gus Garcia and Carlos Cadena from San Antonio, as well as James de Anata from Houston. This court case paves the way for Latinos to use the legal system as a, redress. It was an attack on segregation of Latinos in Texas juries. And here's what makes it so interesting. LULAC lawyers had appealed the Hernandez decision, arguing it violated Hernandez's constitutional right of a trial by jury of his peers, since no person of color was on the jury. Now, of course, these lawyers would argue then that the 14th Amendment should also apply to all ethno-racial groups, and that Latinos in particular should benefit from the Equal Protection Clause of the 14th Amendment. But what they argued here was very fascinating, very interesting. Their argument under the 14th Amendment became known as the class apart theory. They said that despite having a distinct history and culture, Mexican Americans were considered white by law. That's a fact. And what LULAC's been claiming all along, right? This was fact. Since the Treaty of Guadalupe Hidalgo, they were in fact white by law. Established. It's something LULAC had been claiming for years. But the Hernandez lawyers argue that in reality, despite being white by law, Mexicanos, other Latino groups, were in reality subjected to prejudice and discrimination. They said this was reflected in the Hernandez trial, in which none of the jurors selected were Mexican American. But if Latinos were white by law, then would not Anglo jurists be of his peers? And the lawyer said, no, this is not the case. Because of the rampant discrimination and racism and bigotry and prejudice, those Anglo jurists were not of their peers, despite being of the same so-called race. And so the lawyers argue what became known as a class apart theory, asserting that the 14th Amendment should also apply to Mexican Americans as a recognized class of white people. This was a variation on what was called the other white theory. See, the state of Texas was arguing that Mexican Americans are legally classified as white, and therefore that the 14th Amendment only applied to covered, whites and blacks, in that Mexican Americans are whites. And therefore, there was a jury of his peers. But Garcia, on behalf of Hernandez, was arguing the 14th Amendment guaranteed protection not only on the basis of race, Caucasian and Negro, but also class. Those who administrated the process of jury selection introduced discrimination based on exclusion of class. The state of Texas admitted that no person with a Spanish surname had served on any type of jury for at least 25 years. But also that they argue that this absence was only coincidence, not a pattern of behavior. But Garcia and his associates presented comprehensive evidence that in Jackson County, discrimination and segregation were common practice, and that Mexican Americans were being treated as a class apart. They may be legally white, but they weren't being treated as white. They were a class apart, or as I've said before, they were second-class whites or second-class citizens. And Chief Justice Earl Warren, the same Earl Warren from the Mendes case in California back in 1945, delivered the unanimous opinion of the court in favor of Hernandez and ordered a reversal of the conviction. The Supreme Court accepted the concept of distinction by class. That is, there is a difference between white and what we now call Hispanic, but white and brown, and found that when laws produce unreasonable and different treatment on such a basis, the constitutional guarantee of equal protection is violated. And they ruled in this case that Mexican Americans, as a separate class of white people, could not be excluded from juries. What this signified was that the concept of Latino identity began to shift as the demand for inclusion in the political and judicial system began. And again, this is a notable victory. But once again, it simultaneously pitted Mexican Americans against other ethno-racial minority groups. So they're still hanging on the idea that they are white. And in doing so, yes, they win the discrimination suit to serve on juries. They've won discrimination suits to, sit in white schools. But as other groups are suffering, such as African Americans. This paradoxical victory was evident. This class apart theory, while it was a winnable strategy, and while it probably was true in many ways, this paradoxical victory of Hernandez, though, was evident in one of the biggest, most well-known Supreme Court cases regarding school segregation that occurred the same year. And that, of course, is Brown v. Board of Education. In 1954, African American civil rights movement finally scored a sweeping, unmitigated victory in the Brown v. Board of Education Supreme Court case. Now, the case had originated in Topeka, Kansas, in a racially segregated school system. And in the end, the Brown case ended up combining with 4 other cases from other states before going to the Supreme Court, where Thurgood Marshall sought to finally overturn the separate but equal doctrine once and for all. In 1954 ruling, the Supreme Court handed down the opinion that, quote, in the field of public education, the doctrine of separate but equal has no place, unquote. What made this decision different was that, yes, Houston and Marshall would argue the 14th Amendment Equal Protection Clause. But the court also cited psychological and sociological findings that demonstrate that even if separate facilities were actually equal in quality, which they never were, but if they were even, just the act of separating people based on race engendered feelings of inferiority and difference. This was a clear reversal of the Plessy versus Ferguson 1890 doctrine of separate but equal. And it was unanimous. But there was a problem. Yes, the ruling was unanimous. Yes, it's a major victory in history. The ruling ordered the integration of public schools, yes, but it provided no timetable for integration. All it said was that racial integration should move with, quote, all deliberate speed, unquote. What do you think all deliberate speed meant to southern states like Mississippi? Of course, all deliberate speed means different things to different people. It was vague enough to allow southern states leniency in enforcing the new ruling. Integration, in other words, was at the discretion of the school and state officials. And so many times, it was a long, slow process. Some states favored what was called staggered integration. In other words, one grade at a time. And there is some validity here. The idea being start with the youngest kids. Start them as kindergartners or first graders. So in first grade, you integrate the first grade class. And that way, as they move up, they've never known anything different. So every year you will get one more grade added. So when the first graders become second graders, now the second grade was integrated. And the first grade is integrated once again. The third year, now the grades 1 through 3 are integrated. The fourth year, grades 1 through 4. And over the course of 12 years, you will fully integrate your school system. Slow. Maybe it might help deal with some of the violence issues. Maybe. And the thing is, though, that was considered the good solution for many places. The far more devious policy was called pairing. In other words, they would do was the integrating of Latinos and Blacks or other students of color while leaving the white schools untouched. So this decision was, hey, you know what? We're going to leave all white schools being white only. But what we're going to do to integrate schools was to mix the Mexican school with the Black school. So we will integrate Latinos and African Americans. And why? Well, obviously racist reasons and to preserve white-only schools. But under the law, Latinos are white. They are part of the white race, right? That's been the decision since the Treaty of Guadalupe-Hidalgo. That's what LULAC has been arguing. That's what the Hernandez case established. They may have been a separate class of white, a second class or lower class, but they were still white. And so therefore, if you integrate and merge the Black school and the Mexican school, you've now mixed Black and white. And so since Latinos are legally classified as white, many districts simply merge them with the Asians, the African Americans, the Native Americans, arguing that, yep, we follow federal law. And once again, I hate to say this, but that was actually the good way they did things. Because at least they were trying to actually, again, deviously, horribly, unethically, wrongly doing it. But at least that didn't end in violence, as opposed to the rest of the strategy of the South, which was massive resistance. You see, in response to the Brown decision, it will spark what we call massive resistance in the South. Most visibly, these court-ordered integrations will spark the formation of what are called white citizens' councils. These councils didn't just use violence and intimidation the way the KKK would, although violence would sometimes be included. Instead, they used economic coercion to maintain white supremacy. These councils would include prominent members of society like politicians and business owners and bankers, and African Americans who tried to defy white supremacy or send their kids to a white school would lose their jobs, have their insurance policies canceled, denied personal loans or home mortgages. And these councils became so powerful that membership became a prerequisite for any aspiring white politician in the South. And these white councils sparked another strategy to defy the Brown ruling, known as massive resistance, defiance at all cost. In fact, school buildings and entire school districts were shut down rather than integrate with compliance with the ruling. Oh yes, all deliberate speed means different things to different people. And these southern states had no intention of letting segregation go without a fight, whether it was staggered integration or whether it was, the merging of Black and Latino schools or whether it was massive resistance shutting down the school altogether. And yes, this did happen. Now, the political manifestation of massive resistance was known as the Southern Manifesto. Written in February of 1956, drafted by Strom Thurmond, signed by 100 politicians. The document ordered the Supreme Court ruling, claiming that the Brown v. Board of Education ruling was a, quote, clear abuse of judicial power, unquote. And that these politicians were pledging to support any state that, quote, resisted forced integration by any lawful means, unquote. This is harkening back to the Civil War issues that are insisting the problem was a matter of states' rights, insisting that segregation was a state matter, and the federal government was infringing upon their rights of the states with the Brown decision, despite the constitutional amendment, 14th Amendment. So you have the massive resistance of close the school down if you have to. You have the Southern Manifesto. You have the white citizens councils who are using economic means. You have staggered integration and the mixing of Black and Latino schools. And then, of course, the most extreme position, of course, is the resurgence of the KKK, or KKK 3.0. We will see this extreme patriotism of the 1950s and the early Cold War era combined with the white supremacy ideologies, leading to a resurgence of the KKK. And look at the bottom right corner. They are literally doing a Nazi salute. They are infusing with this fascist, white supremacy, neo-Nazi style of ideology. The 1950 Klan were still equal opportunity haters, but now opposed also to integration, bombing houses, intimidating with violence, and assassinating activists. In southern states, the Klan was able to heavily influence the police and governments, especially in Alabama and Mississippi. And the Soviet Union would capitalize on the Klan, especially in third world countries, saying, wait, you want to emulate the United States democracy? Look what's happening in their country. Look at the Klan. And they were able to portray a racially divided United States. As a result of all this massive resistance throughout the country, Latino advances, despite being classified as white, were usually met with massive resistance from both whites and blacks. Now, surely some, both whites and blacks, did support integration, obviously, but most did not. For whites, it went against conventional practices and social norms. But the loudest and most agitated opposers to integration absolutely despised Latino advances. They would often beat, picket, and sometimes kill Latino activists as well as their supporters. And of course, here in Texas, many whites, especially in Texas, sought to pass legislation to preserve segregation. In fact, here in Texas, in the late 1950s, in the post-Brown v. Board of Education decision, they would be introduced dozens of bills to limit any advances for Mexicanos here in Texas. In 1957, Henry B. Gonzalez, the first Mexican-American elected to San Antonio City Council, and later the first Mexican-American state senator in at least 110 years, along with Senator Abraham Kazin, attracted national attention for holding the longest filibuster in the history of this Texas legislature. He stood and talked. The filibuster itself lasted for 36 hours. Henry B. Gonzalez himself spoke for 22 hours straight. And there was some success. In doing so, he and Kazin would successfully succeed in killing 8 of the 10 racial segregation bills aimed at circumventing the Supreme Court's Brown v. Board of Education decision. Again, still 2 passed, but this is a victory nonetheless. So you can see this is a very tumultuous time. This was not major victory. Supreme Court case decides and everything's good after that. No, no. Desegregation takes work. It takes a fight. Yes, the law, federal law is on their side. And because of a failed coalition between blacks and browns, it will kind of prolong it. It will hamper a larger coalition that could have fought together. And there are notable reasons. There's arguments. This is not right and wrong. This is gray in the middle. But the result of these major decisions is going to push forward the civil rights movement as the clock turns to the 1960s. That's a topic for next time. So until then, take care and bye-bye.